too am asking you on this day to choose him and find him not guilty of every single charge in that indictment. Thank you.
Thank you, Ms. Howell. Ladies and gentlemen, let's take a 15-minute recess. We'll come back for the state's final word.
All right, Jerry.
Put your phones on silence. We're trying to go over. Council, let me see if you're here. Mr. Perry?
Morning, everyone. Morning. Before I start, I want to do one thing. I want to make it very clear, because no matter what happened that day, Mr. Thomas deserves to be known by his actual name of James Thomas. He is deceased. That family has to think of him every single day. It is not Anthony Thomas. The name's James Thomas. It should be ringing through each and every one of your heads, because that's the man that was murdered. Now, I know both sides here, we get up to 2 hours, and I'm sorry. I'm going to take a lot of that 2 hours, because James Thomas deserves that. I'm just going to go into the lunch, and I'm going to cover the law, and it's going to be boring, but it's important, because the details matter. When this trial started, I told you what some of the most important facts are, and those facts are still the facts at the end of this trial. I told you James Thomas was unarmed. What did the evidence show? James Thomas was unarmed. I told you he was more than 2.5 lanes away when he was shot. It was estimated, what, about 40 feet? I want y'all to look at your notes. I'm going off of memory here, but I think it was estimated about 40 feet away. Undisputed. Evidence bore that out. And I told you that after shooting 3 times at the victim, causing a crash on the bridge, he fled the scene. And you heard the recorded interview, and in case there's any doubt, despite what he said on the stand, you're going to hear the recorded interview again, that portion where he says, I knew it was wrong to leave. If you didn't do anything wrong, then it's not wrong to leave. And that he admitted he never saw a gun, and that was no threat. And you heard the recorded interview. Windows were tinted when asked about a gun. Nothing said. No kind of threats. And I asked this question, right? I said, at the end of this trial, this is going to be question number 1. And you got to go 2 for 2 here. Is it reasonable for a person justified to use deadly force against an unarmed person who has made no threats, who is more than 2.5 lanes away, and then to do so putting everyone else in the roadway in danger? Second, is there anything the defendant could have done short of shooting the victim? This is not burden shifting. This is following the law. And the law is what's called excessive force. And at the end of my presentation, I'm going to cover in detail what excessive force is. But to preview it very briefly for you, you are only allowed to use such force as is necessary, meaning no other options, necessary, required, to stop a threat. Meaning if there's anything you could do short of using deadly force, you are required to do so. And so those are the questions you have to ask. And before I go into the law, I want to address some of the smoke and mirrors that you all have seen throughout this trial. You know, it's almost like a magic show rather than a trial. Sitting here having to navigate through the smoke of this or that. He's a predator and all this other nonsense meant to distract you from the truth that that man murdered James Thomas without justification. How long did we spend on this trial, y'all? Talking about vests in the car? How long? And what is the question? The question is, did the defendant know? Would that have had any kind of impact on his decision if he knew, or did he know, that the officer was an officer, an off-duty officer? He said he didn't see it. He didn't know. He wouldn't shoot if he was an officer. And the question is whether or not somebody with the information that the defendant had at the time that he made his decision would have done so and done so reasonably. That has no bearing whatsoever on this case. And also, talking about how he's a predator, he had a vest in the car, or he was walking out with it and all that. He ain't exactly the cleanest officer. All right? If he has a fault, it's probably because he's not that clean. And you can see the junk thrown over it. And let's also not forget, he was working in an off-duty police job at Brady Hospital. What do you think he drove home from it? Of course he's going to have police stuff in his car when he works off-duty police jobs. Even Scott Denister told you, yeah, I've got stuff in the car. It shouldn't be shocking that somebody has things that are related to their work in their vehicle. But again, it doesn't matter because the question is, what did the defendant know and what impact did that have? It's a smoke and mirror. Talked about the duty to retreat. We're not disputing you don't have a duty to retreat. What we're telling you is that the conduct itself showed that he wasn't in fear. And duty to retreat only comes up when the other person is an actual aggressor. Going ahead and pulling up inside and hitting on somebody is not being aggressive. There's no physical force. So duty to retreat is not applicable. But where that's also coming about not scooting off on that second time, or not waving somebody down or going to the woods after that second time, that's all showing whether or not he truly feared for his safety. Never pointed a shotgun or threatened, right? Because he had all this talk about, well, he had a shotgun, and if somebody, remember that testimony, Detective Meester, if I point a shotgun at you, you're going to submit, right? Y'all, the shotgun's in a trunk. Of course he would submit if a shotgun was pointed at him, but that's a made-up fact. That didn't happen. And we're going to cover that other photo here in another second because I had to do quite a few edits to my PowerPoint during that closing, okay? Talking about smoke and mirrors, about, oh, there's ammo in the car. Yeah, he's a cop. He's got ammo in his car. The defendant didn't see any ammo, so that has no bearing on whether or not the defendant reasonably feared for his safety, or whether or not anybody who is a reasonable person in the defendant's position would fear safety. We're talking traffic laws. We're talking about upholding your duty to make sure that you're not impeding traffic when you're not in uniform in your off-duty car. That is what this case devolved into, not James Thomas being murdered in his car. Where he was headed, that's not what we're here about. But we already heard, hey, he's headed off to an apartment complex. He works a midnight shift, okay? Switch it around. If you're working a 9 to 5, when he heads out 4 hours later, that's like him heading out at his 9 p.m., okay? He's allowed to work a midnight shift and then go ahead and enjoy the rest of his day. But where he is headed, we know that he's headed somewhere because he's actually got directions in there, right? It's not as though his GPS is leading him and following him all the way to the defendant. And this idea, you don't know when he put the GPS in. I ask you to use your common sense and ask yourself whether it's reasonable for somebody to be driving or put directions into a call, into your phone, and then still have that hooked in your car if you're not actually going in that location. And having to hear constantly, turn left, turn right. Does that make any sense? It doesn't. It's just meant to distract you because the reality is, what matters is what took place on Bolton Road. He could have been going anywhere. He could have been going off to rob a bank. Doesn't matter. It's what did he know, the defendant, at the time, and what would a reasonable person in that position do? You heard it just, what, 45 minutes ago? Made sure he went out there, credentials and raincoat in hand. He didn't leave his apartment with that. He had left his stuff in his car. No explanation. We already just covered that for why the jacket or the vest is in the car. Scott Denister told you that. And it's offensive. It's just outright offensive that even in his death, he is still being victimized here as to his reputation. Salt in the grave. This random speculation with no basis in evidence. But let's go ahead and entertain this for 1 second. Okay? This has no bearing, but I'm going to entertain you all as to this master plan that James Thomas apparently has. Okay, James Thomas is going to work his off-duty law enforcement job at a hospital, come home, order some DoorDash so that way he's carved up before he goes out to hunt, go out wearing his slides without getting the gun out of the trunk to go and then cruise up and not, by the way, if you wanted to go ahead and lure the prey, right? We know a lot of kind of predators can go ahead and use traps like fancy colors and bring you in. But not even use the kind of items that might be able to disarm the suspicions of the defendant. Not going to say, hey, I'm a cop. Does that make any sense? And when I talked about the height and the weight, right? He's going to then go ahead and choose somebody from 2.5 lanes over who is significantly larger than him. That's going to be who he's going to prey on without even getting a shotgun out of the trunk, without maybe pulling back up, because we already know that he can drive up and then do a U-ey again if he wanted to do it. Why wait until have to be the 4th time of driving back up? He didn't put his vehicle in park. It's nonsense meant to distract you, and it's offensive to the memory of James Thomas. James' conduct while being an off-duty officer means there's some kind of status. That is not the law. That is not the law. James Thomas' profession and what he did in his off hours has no bearing whatsoever on whether or not the defendant was justified in murdering him. It's offensive. Talked about, oh, never touched this DNA. You heard it. He never touched the car. He never got in the car. They solved this within about 4 or 5 days. So even though the defendant admits he didn't touch the car, even though the defendant admits he never got in the car, we're supposed to go ahead and still send those swabs off to GBI, who anybody who watches the news knows how swamped they are, so that way they can work up something where we know no evidence is going to come back, delaying what? How many rape kits, right? That's nonsense, and that's dangerous. Shotgun on top of Titus, no, that's not what it was. These are the photos. You all see it. See that second photo? That's when the shotgun is actually shown with the placard. This is what it looked like on the left when they opened the trunk. Exactly as Scott DeMeester told you. It was buried in there, had to remove items. It's not true when defense attorney tells you that. It's just not, because the photos bear that out. He wouldn't be shot if he was not up in his face. Y'all heard that. And what does the medical science tell you? No soot, no stippling. If so angry, and by the way, it's not Newsom, it's Mr. Widener, in case you were wondering who Mr. Newsom is. Travis Widener. If so angry, why riding in the car? Well, one, he's got a ride with Eugene. Great. And what was it? It was, he's normally calm, but he can get upset very quickly. And that's what happened here. He's normally calm. He's normally chill. But just like Travis told you, he got upset pretty quickly. And that's why he acted irrationally. Didn't call 911 because the victim could have flipped the script because he is an officer. It's offensive to your intellect when that argument is made. Because we have established again and again, the defendant didn't know that the victim was an officer. So that has no bearing whatsoever on why the defendant didn't call 911. We're going to talk about the law for a while here, okay? And what your duty is, okay? Your duty as a juror is to be fair and impartial and honestly seek the truth. When you raise your right hand, that's what you said, the truth. Not to seek doubt, the truth. And you have that duty to deliberate. And if somebody's not deliberating, you need to let the judge know. And these are the things in that circle that you are to consider. And it's tough, I get it. We all have our own personal beliefs, our own potential sympathies. But when you raised your right hand and you swore to that oath, this is what you swore to follow. To look at the law, to listen to the testimony of the experts. In this case, you had expert testimony from the medical examiner, and we stipulated about the testimony of the firearm examiner. The testimony of the witnesses. Motive to lie, which I'm going to cover next. Forensic evidence, right? We heard that about the ballistics. Elements of the crime and common sense. Your personal feelings need to be set aside in the case to follow this. Not your passion, not whether or not you're concerned, what the public may say, not if you have any issues with the police, not if you have any kind of sentiment or sympathy, either for or against the defendant. If you're not sympathetic against the defendant, don't hold it against him, but if you're sympathetic, you can't use that to justify deviating from the law. I'm going to cover what excessive force is. You have a sworn duty to follow what the law is, even if you don't agree with the law in Georgia is. If you agree the law is what it is, if applied to this case, despite your personal beliefs, you must convict. When I go over that. Conjecture, oh boy, we heard a lot of if, well, maybe this, maybe that, this, that, what if. It's conjecture. You go off of facts. You go off of evidence. Not to concern yourself with penalty and punishment, and you're not to concern yourself with any kind of prejudice in this case. I know that when we talk, sometimes, we're in Atlanta, but we're still sometimes in the South, and sometimes we still do run into that prejudice about homosexuality. I'm not saying, and I don't believe that's the case for any of you, but to the extent any of that exists, you need to set that aside. We talk about motive to lie. I want you to hear, because he told police that he was telling the full truth.
What we're doing, and part of that is on me to be completely forthcoming with you. And we already obviously had reason to believe that you were the one that was standing out there that day, or else we wouldn't be sitting here in this Publix park. I'm not talking about this, you know what I'm saying? So we've been trying to do our best, but our best in any investigation isn't just about finding one side of things. It's about finding the truth of things. It's about investigating everything fully. Yeah. Okay. All right.
He tells police that everything he told them then was the full truth. That also means not leaving out facts that magically happen when he's on the stand. But let's go ahead and clear up this timeline, right? Let's talk about being stalked for 11 minutes. Upper right-hand corner. He walks off at about 4:22:44. James drives by at 4:25:20. Now, you've also got to factor in the time it's going to take James to catch up to him. Okay? And you all mark down when those gunshots happened at 4:31:44. We already went through that. We played that for you. The math doesn't math for this idea of stalking for 2 minutes.
That morning I got to work. I was headed home. The car posted there nowhere. Asked me if I need a ride. Said no, I'm straight. Kept walking. Now he drove off. Came back again.
The full truth? That's the full truth right there. All of a sudden now we're inventing facts that don't even fit what we know the timeline is. The man he get into the car, if you're telling the full truth and you're in fear for your safety and you're trying to clear your name like he said he was, you do not hold back about a demand to get into the car. It's a let's. Let me get you.
Get in, let me get a ride. I don't know what the fuck you got going on, but I'm straight. Went to 3 to 4 times. Third time came back. I asked his wife for my eye. And the car went straight down the street.
Play it one more time for you.
Came back again. Get in, let me get a ride. I don't know what the fuck you got going on, but I'm straight.
Get in, let me give you a ride. Let me give you a ride. I don't know what the fuck you got going on, Monster. Really? Let me give you a ride as a demand that you feel is overwhelming, that you're going to be kidnapped, that you fear for your safety, to the point you are going to need to use deadly force in the next encounter. Right? And we already showed this one here. The headlights being off. Y'all saw that video. The headlights were on. Here we go. There he is walking, and the headlights are on. They're just adding and making up facts, but it doesn't fit the evidence when you actually go and peer through these smoke and mirrors.
Or brandish a firearm or anything
I don't, it's nighttime, I can't see.
yeah,
It's dark.
it's a situation that you were scared of.
Windows looking a little tint, I can't see in them, you know, down. As I was taught, it's a lot of, and then thing about it, I see a lot of stuff happening on the news.
You could see fumbling in the car now, I understand he's saying that, but when he was talking to cops, he couldn't see anything.
Like I said, at that point, I know it's wrong to leave that scene.
Yeah.
And well, I know I have to leave that scene.
Yeah.
I knew it was wrong to leave the scene. Oh, this is a big one, y'all. Because we talk about motive to lie, we talk about victim, and we talk about witness credibility, right? If somebody's lying to you about this, they're going to lie to you about something else. What did he get up here and tell y'all? What do you do? I just turned around. I wasn't shooting anything. I wasn't shooting him. You know, I just figured I just turned. Why are we shooting down? And then we had this whole thing about the grouping, and no, I wasn't shooting at the car. It's a lie.
Word hit a car and then he went that
Back
way.
up this way. I got 2 shots. Toward the driver. Toward the driver window. Was no passenger, the driver window. And shot out that way.
Yeah.
Let off 3 shots, the driver window. Let me show you all again.
Word hit a car and then he went that
back
way.
up this way. I got 2 shots. Toward the driver. Toward the driver window. Was no passenger, the driver window. And shot out that way.
Yeah.
And then I guess it hit the other car that came past.
All right.
Window. He made sure to be clear, I wasn't shooting at the passenger window. So when he got up there, he said that, he looked at y'all and he was lying to you. Shot when the car was coming at him at a high rate of speed, right? We all heard that. The ballistics don't add up to that, because what happens if James Thomas is right here and the car is coming? Raises, shoots as the car is coming. Where are the bullet holes going to be? Where are the bullet holes going to be? They're going to be in that front windshield. Where are they? They're on the side. Now, I don't know what kind of matrix bullets he has at the curve, but I haven't seen them. He shot James Thomas when the brake lights are already there, and James Thomas is on the side with the window down, about to go ahead and shoot his shot one more time. All right, I want to talk about the presumption of innocence, because there is a burden. The defendant is presumed innocent. Every defendant is presumed innocent, no matter how guilty they are. They begin with a presumption of innocence. That is a hallmark of our judicial system. It is the state's burden to disprove that. But it's just that, a presumption. And once we go ahead and we provide this evidence and you use your common sense and reason, we overcome that presumption. And what is reasonable doubt? It's exactly what it means, right? It's a doubt that can be based upon common sense and reason. It's not a vague or arbitrary doubt. It's not to a mathematical certainty. I can't tell you a certain percentage. It's just you know when you know, right? Somebody tells you something, you go, that doesn't sound right. If that's the case, if you don't have, that doesn't sound right, that doesn't make sense, that's the situation. And we all were picked because of common sense and reason. When you all woke up and you got those juror summons, after you probably let off a couple 4-letter words, right? Calm down, got your common sense, came in, went through the sweat iron. We asked you questions, you had your common sense, you've been sitting there all day, yesterday, Monday, had your common sense, and when you go back in there to deliberate, you will deliberate using your common sense and reason. It's not whether or not the state answered all of my questions. It is whether or not, using your common sense and reason, we prove the case beyond a reasonable doubt. I'm never going to be able to answer all y'all's questions. That's not the burden. The burden is, here are the elements of the crime. Did the defendant do these elements? Was the defendant justified in doing so? did the defendant have or used excessive force that then would discount that justification? Those are your only questions when it comes to whether or not the state proved its case. And there's what we call direct and there's circumstantial evidence, right? Direct evidence, something that points immediately to the issue. What a witness saw, what they heard, you see videos, you see photos, and there's what we call circumstantial evidence. And we use circumstantial evidence every time in our lives. It's things that are proof of facts by direct evidence from which you can infer other things. So what do I mean by that, right? I'm using a lot of legal terms. I'm going to give you a great example. Something I thought, based upon the warnings last night, we all were going to have to encounter today. So this is not the greatest photo, but I thought it was going to be a pretty good photo when I went to bed last night. So you're getting ready to go to bed. You can hear in the distance some booms, okay? Maybe you can see in the distance some flashes. And as you're falling asleep, you start hearing a pitter-patter. And then that pitter-patter gets louder and louder and louder. And you drift off to that sound. And when you wake up and you go outside, everything is soaked. Maybe it's still a little bit overcast. Using your common sense and reason, what happened? It rained. Did you see it rain? No. But solely, exclusively, off of circumstantial evidence, if somebody told you some other theory, you would laugh them out the door, right? Somebody said, no, it didn't rain. There was actually a Boeing 737 that came by and it just dropped all the water right on your house. You go, get real. You serious? Because that doesn't make sense. Is it possible? Sure. But just because something is possible doesn't mean when you use your common sense and reason, it's reasonable. And the law doesn't require a higher or greater degree of certainty based upon circumstantial or direct evidence. This case has murder, felony murder, aggravated assault, and criminal damage to property in the second degree. We're going to talk about murder and how it's different from felony murder. And I'm also going to talk about aggravated assault and criminal damage to property in the second degree. So the felony murder, if you find the defendant guilty of aggravated assault and you find somebody died during that aggravated assault, you also have to find the defendant guilty of felony murder. If you find the defendant did criminal damage to property in the first degree and someone died in the commission of that, that also means, in addition to being guilty of criminal damage to property in the first degree, is guilty of that felony murder. And I'm going to cover these more in depth here. I see some people writing, so I'm going to go ahead and give you all an opportunity to write that down. You will have a copy of the indictment, and it will have those charges. Let's talk about count one. Person is guilty of murder when a person unlawfully, with malice of forethought, causes the death of another human being. We all can agree the defendant caused the death of James Thompson. So what is malice of forethought? It's either deliberate, or it's either expressed, or it's implied. Understand that malice does not mean ill will or hatred. It is a legal term. Malice means an intent to kill. When you point a firearm and you shoot a driver's side window and try to shoot the driver's side window 3 times, that is a deliberate intent to kill. There also can be what we call implied. Understand, this has nothing to do with good character or bad character. Zero. Has nothing to do with hatred. It's simply, were the conditions in which the defendant caused the death the kind of conditions that show an abandoned or malignant heart, right? A do not care attitude about the kind of harm that can be caused to him or others. And we have both here. There's a deliberate attempt to kill.
And then he went that way.
This way. I got 2 shots toward the driver. Changed the driver window. Was passing the driver window and shot out that way.
Yeah.
And then I guess he hit the other car that came past him.
People
All right,
intend illogical conclusions from their actions. And the logical conclusion when you shoot at somebody through a window, attempting to do so 3 times, is you're going to kill them. That means that there is express. It doesn't mean he dislikes him. What it just simply means is he knew his actions were likely to take the life. And then the abandoned malignant heart. His actions in shooting in a road that, by the way, has this truck, James' vehicle, Fantasia's vehicle, a vehicle coming over a bridge, by the way.
It happened right in front of me.
Put every single one of those people's lives at risk.
Nigga, they ahead of me.
And what does he do? Does he check on anybody that he might have hurt? No. He flees. It's an abandoned heart when you put every single one of those persons' lives at risk in this manner. You know that what you're doing can hurt people, but you still do it anyway. Understand also, you're not going to hear the word premeditation because that's on TV. That ain't in Georgia. Georgia requires no premeditation. All it requires is malice, which we just covered, right? The intent, the either express intent to deliberately take a life, or doing it and doing that action in a way that just puts everybody at risk, such that you show that abandoned malignant heart. And that can be formed in a second. And we know that's there, and we know that's present. Even with one shot, even in that very moment that first shot comes out, that very second it can be formed. But in this case, it goes even farther than that. It goes beyond 1. It goes to 2. It goes to 3. And then, in addition, there's what we call felony murder. Now, we don't have to show that he even intended to kill. We don't even have to show that he has a malignant or abandoned heart. If those exist, he's still guilty of this. Understand? If that malice exists, he is still guilty of felony murder if he committed that felony. But what felony murder also says is that you don't need to have that intent to deliberately take a life or do your action in a manner that shows abandon or malignant heart. All that matters is, did you do this underlying crime, this underlying felony? If the answer is yes, step 2, did someone die? And was it as a result of that underlying felony? If the answer to that is yes, the math finally maths, and it's guilty. Is he involved in an aggravated assault? He told you. He's shot. He did the aggravated assault. He shot and killed James. But just the shot alone, even without intending to kill, if James dies as a result, it is felony murder. You just heard twice the video where he admits that he shot at the car. And that's going to be criminal damage to property. But we're going to get to that in a moment here. All right, we just covered the aggravated assault. Count 3 is the felony murder for criminal damage to property in the first degree. And that's where you knowingly and willfully, which he said, he knowingly shot without authority. James Thomas sure as hell didn't consent to being shot at 3 times. Shot his vehicle in a manner so as to endanger human life. So even in the shooting, when he's shooting at that vehicle, we know Fantasia Sim's vehicle is also right there. He puts not just James Thomas's life at risk, but Fantasia Sim's life at risk. Not only that, he also puts everybody that's on that roadway, especially those that are coming forward over a bridge to those vehicles that can cause that potential head-on collision. So did he shoot a vehicle in a manner that endangered human life? The answer is yes. Did someone die as a result of that? The answer is yes. Therefore, you are guilty under both criminal damage to property in the first degree, as well as the felony murder based upon criminal damage to property in the first degree. Understand, we don't have to prove motive. That is not required. heard from Travis Widener about how easily he can go. So he's normally real chill, but he can go from, you can get upset real quick. And that's the motive here. He got upset. This guy's hassling him, questions his manhood, and he just pops one off, or three off, because he's upset, he's tired, and wants to be left alone when he's going home from work. That's your motive, is he was insecure about his own masculinity, and he's tired, and he's frustrated, and he's going to go ahead and show his masculinity by pulling out his big stick and firing. Justification. A defendant is justified in using force that is intended or likely to cause death or serious bodily injury when he reasonably believes that the use of such force is necessary to prevent death or serious bodily injury to himself or the commission of a forcible felony, which means a felony that involves the use of threat or force or violence against another. And we're going to go more in depth on each of these, okay? There are three requirements, and this is before we even get to excessive force. Understand that. Three requirements. The defendant has to believe that his threat of use or use of force is necessary to prevent exactly what we just talked about, death or serious bodily injury. The defendant has to believe it. Number two, a reasonable person has to believe that, not just the defendant, but it's almost like if you're watching football, right? And they go ahead and throw that challenge flag. The reasonable person is going to watch that video of that play and make their determination. So on that challenge flag, when that's thrown and they start inspecting it, does it hold up? And then number three, it has to be what prompts him to threaten or use the force. So let's talk about that first requirement.
You know what's going to happen, right? You're going to be charged. And I know you said you want to clear your name. You're going to be given the opportunity.
I'm going to get charged in that self-defense.
So here's the problem. When the police shoot someone that doesn't have a gun and we say we're afraid for our lives, the police...
I didn't say that.
Didn't say what? That you were afraid for your life?
I didn't say that part.
Okay. You were just scared.
He fluctuates back and forth, but where does he end up at the end?
They self-defense, right.
His final thing where he finally lands after the end of his interview is, I didn't say that. I shot because of self-defense. I didn't say that. I was afraid for my life. Now, did he say that earlier? Yeah. He said he saw a light flash. But here's the point. He's not even certain about that. And you have to be certain. Flight is consciousness of guilt. They want you to go ahead and believe what Alfred Burley gets up here, and Alfred Burley says he's a calm person. I don't think he would do that. But they don't want you to believe that Alfred Burley also was told that he had changed his clothes and was avoiding police and taking a different route. It's all or nothing, y'all. And I submit to you the reason why he fled, the reason why he is evading police, the reason why he's even telling his friend Matt is because he knew he'd done F'd up.
Like I said, at that point, I know it's wrong to leave that scene.
Yeah.
And I went home. I know I didn't leave that scene.
Yeah.
If your actions cause a crash and put others also at risk, a person that is a victim lets the authority know why this happened and to check on people.
So the car, when it swerved over, it must have almost hit you, huh? It wasn't that far from where you would have been
I
standing.
was on the sidewalk.
Yeah, so you were on the sidewalk and he was going this direction. We know that he swerved, hit a car, and then he went that way.
Up this way. I got 2 shots toward the driver. It was the driver window. Was passenger with the driver window and shot out that way.
Yeah.
And then I guess hit the other car that came past.
If the other car that came past, his actions put other people at risk, and he doesn't even call 911. Common sense and reason, y'all. He's on the sidewalk. When he's firing this gun, shell casings going, law enforcement's out there, canines. Defense tries to say, oh, it's dark. No. You heard from the canine handler. They were running dogs up and down. both when they first got there during daylight and they even came back. Where are the shell casings? Now, if you use your common sense and reason, why is there not one? Why is there not two? Why is there not three? There should be at least one if he's not picking those up. You want to know why, when that truck drives past, that you don't see him on the sides? Because he ran into the woods after he shot him, which is exactly what Burley's talking about, taking a different route. Picks up the shell casings, runs into the woods. You don't tamper with evidence if you are a victim. Now let's talk about what a reasonable person would do, because this is also required. Would a reasonable person believe that there is no other option but pointing that gun and firing 3 times at a driver's side window on a roadway that has other vehicles on it, when you never saw a gun, never had a threat of harm, 2.5 lanes away, vehicle's not even in park, the door is not open, there are other vehicles you can wave down. We all saw videos of cars coming and going, including the truck, right? Y'all remember that portion from Herman Broadus? Didn't appear that there were any kind of people in distress when you drove by, right? No pedestrians in distress. No. Plenty of cars to wave down. We all saw the timeline, only a few minutes away from the store. Also, you got your, I'm still going to call it a skateboard because I don't know what it changed into between closing and this, but still got some kind of object you can get on. Has a cell phone. He's armed, so there's other options. And was there a corner store 2 blocks away? So challenge flag thrown when the defendant says that I actually truly feared for my safety. Take it up for review. What does the review say? Call overturned because of these facts. That is not reasonable. That there is nothing. This is your only option. It is necessary. It is required that you use deadly force in the manner that you did. All right, excessive force. This is the most important charge in this case. A defendant is not justified in using excessive force while acting in self-defense. Even if the defendant hit those earlier criteria of being justified, you cannot take it from 0 to 100. Just like I said in opening, you've got to take any other step short of that before you use deadly force. If you decide the defendant used more force than was reasonably necessary to defend against the alleged victim's threats or use of force, then it is not justified. And if it's not justified, it's undisputed about guilt. Option number 1. Is this an option that could have been done? Again? Nah, I'm good. Leave me alone. Continue anyway. I'm good. Should that have been tried before firing 3 times into a roadway at a driver's side window? Should that have been done? If the answer is yes, then your verdict is guilty. Number 2, something that unfortunately I think every single woman knows when they are being hollered at. Sometimes just ignore. And that's what he could have done. Could have ignored it. Could have also done what any woman in that position could have done. Call a friend or call 911. Could have done anything that a woman could have also done in that situation. Warn that you're armed if you believe that this is a step that could have been taken before using deadly force. If you believe it could have been done. It doesn't say, I told you once, I'm good on the ride, I told you twice, I don't want to get in and do anything sexual, I got a gun, leave me alone. If that is an option before murdering James Thomas, your verdict has to be guilty. Option number 6. Could have shown it. Could have shown the gun. If that is an option, short of using the gun. Because let's be honest, the phrase is not, if you got a gun, you got to use it. It's, if you got a gun, you got to be prepared to use it. If that is an option, a step that should have been taken before using deadly force, your verdict has to be guilty. If you're, go ahead, not just show it, but actually pull it out and show you mean business. If that is an option, short of pointing that gun and shooting 3 times, if that is just anything that could have been done short of doing that, your sworn duty to uphold the law is that that is excessive force and the defendant is guilty. Point the gun. Let them even know you further in business, right? Now we're almost getting into aggravated assault territory if you're not justified. Because you have pointed the gun. Go on. Could that have been done to a car 40 feet away that wasn't even parked, with the door not open, where there had been no threats and no firearm done? And in the 2 prior interactions, there had been never an attempt to get out the car. Could that have been done? If the answer is yes, your verdict has to be guilty. Option number 9. Can you shoot a warning shot, either into the ground or into the woods? Right? I'm not talking about, oh, shooting in the ground and, oh, I might have shot myself off ballistics. Come on, y'all, use your common sense. There's grass also over there, there's woods, it's offensive to your intellect. Could this have been done? The most extreme situation, short of actually pointing and pulling the trigger. Could it have been a warning shot? Once, twice, 3 times, empty the entire damn magazine, I don't care, while screaming top of your lungs. Is that an option? Could that have been done? If the answer is yes, your verdict has to be guilty. So, what I ask you when you go back there, I believe oftentimes they have a whiteboard. This is the easiest way to reach your verdict when it comes to excessive force. Write out these options. At some point, you will stop. And if you do not stop, and if you stop before you hit number 10, your verdict is guilty. Write that out. Decline. Ignore. Call family member or friend. Call 911. Warn arm. Show arm. Pull the firearm out. Point the gun. Shoot a warning shot. Some of you, I bet, are going to go ahead and once you list and you start voting, you may have 1 or 2, 3, 4, 5, 6, 7, 8, 9, 10, 11 drop after, say number 1, say number 2, but they're going to start getting filtered out. And at some point, as you work your way down through all of those options, none of you will be left. And at that point, 1 through 9 is guilty. Decline, ignore, call family member or friends, call 911, warn have a gun, show have a gun, pull gun out, point gun, fire gun into the ground, any of those. And number 3, the defendant's reasonable belief must be what prompts him to threaten or use force. This goes both ways, y'all. Because they talk about, oh, I might be kidnapped, or he might have a gun, or he might run me over in a car. Would he have used deadly force if the driver of that vehicle was a woman? Would he? If he wouldn't, what prompts him to threaten or use force is the fact that a gay man hit on him, which means that he's not entitled. Y'all, I want to talk about what I consider, and I'm winding down here. I appreciate the patience. I know we're going into your lunch a little bit here. But this is important to me. I've been doing this for a minute. I feel like I get more gray hairs every day, the ones that don't fall out. And throughout time, I've had a lot of mentors. And one of my mentors once told me what the three most important words in the English language are. And the first is truth. It's actually where we get our word verdict from. Verdict means veritas and dictum. Latin. Veritas, truth. Dictum, words, written, right? So when you write down your verdict, that verdict is the truth. And the truth is not always pretty. It's ugly. We don't have to condone James Thomas not leaving him alone. Nobody's saying that he shouldn't have left him alone. What we're saying is that him not leaving him alone and going back a third time, which, by the way, please remember that when he came back that third time, he's just simply going back in the same direction of travel as he was originally going. And when he comes back on that time, that doesn't mean that he should die. The truth is ugly. But you heard it throughout this trial. We didn't shy away from the truth. And when you hear that truth, you are able to do something. Because you're able to do that second word. With that verdict, that truth, you write your verdict. You're able to do another thing. You're able to give justice. Look at him. I know you all don't want to, but look at him. He deserves that. He deserves justice. And that is the role of the jurors. Through the truth of your written words of guilt, you give, finally, justice to James Thomas. But most importantly, you give something else. You give peace. You give peace not just to James, but you give peace to the family that's had to sit throughout this trial and listen to the slander and the insinuations with zero evidence about the character of their loved one. You get to give peace to the family that has been traumatized again and again and again when their son is referred to as an animal. He is not an animal. He was a human being. He was a son. He was a brother. And he deserved respect, and he deserved the right not to have to be 6 feet under the ground. And that's what he took from them when he used excessive force. And your verdict, that truth of guilty, gives not just justice to James. It gives peace, finally, after all these years, to that family. And it gives peace to the community that you live in, to know that we are not the wild, wild west. You don't get to go ahead and just start popping off rounds at people just because they go ahead and solicit you. That is not right. That is not the law. And you give peace of mind to that family. You give peace of mind to the community. And you give peace of mind to James when you render the only verdict that speaks the truth, that he used excessive force and is guilty. Thank you.
All right, thank you, Mr. Perry. Ladies and gentlemen, thank you for the attention you paid during those closing arguments. We're going to go ahead and take a lunch break now. You'll be on your own for lunch today, and we'll give you. We'll shoot to be back at 10 minutes past 1 o'clock. If you have a nice lunch, please continue to follow all the court's previous instructions. Don't discuss the case with anyone. Don't allow anyone to discuss it with you. As soon as I give you the charge, you'll have plenty of time to talk about it.
All right.